a regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms and acquire ammunition shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. Glad you're with us on the program today. We're going to be talking with Chuck Michel, head of the California Rifle and Pistol Association, with Michel and Associates as well, about the big decision from St. Benitez yesterday in California in Rody versus Bonta. Judge Benitez, once again, for the second time, declaring that California's ammunition background check law, which also prohibits Californians from purchasing ammunition online or out of state and then bringing it back into California, is unconstitutional, not only violating their Second Amendment rights, but violating the Dormant Commerce Clause as well. Now, I will say that we talked with Chuck on Wednesday afternoon, just a couple of hours after that decision came down, because Chuck's unavailable today. So we weren't able to get into the appeal by Rob Bonta because that appeal had not yet been made. And things are moving so fast that, I don't know how long this decision is going to be in place before it is stayed by the Ninth Circuit. Hopefully the Ninth Circuit doesn't stay Judge Benitez's decision, but they might very well do so. But for now, anyway, we haven't had Freedom Week yet. I don't even think we've had a full Freedom Day, but there are companies that are shipping to California residents. I presume that there are some gun stores in California that are selling ammunition once again without a background check. And at least for a few hours, again, as of this recording, it appears that Californians are free to travel to Arizona or Nevada to purchase ammunition and then bring it back across state lines without the fear of incurring criminal consequences. So what is the future of Rody versus Bonta? Well, that's where it gets really interesting, because there are a lot of cases that are sort of interconnected and are waiting on movement in another challenge to another California gun law. Chuck Michel explains it all. Take a look and a listen. Chuck, congratulations, sir, on another fantastic victory, this time in Rody versus Bonta.
Yeah, it's a good one and a happy day. Got to hang on to it like all of them, but it's a great launching pad for litigating in the Ninth Circuit and then maybe the Supreme Court.
Absolutely. Yeah. And as regular viewers to Cam & Company can tell by my appearance, I'm wearing what I wore on Wednesday's program. And that's because I'm taping this interview with you on Wednesday afternoon. You're going to be unavailable on Thursday. So thank you for making yourself available today that we could talk about it. But obviously, this is a fast moving situation in the appellate process. We know that Attorney General Rob Bonta is going to appeal to the Ninth Circuit. I don't know what, if anything, the Ninth Circuit will have done by the time this interview airs tomorrow. So I'm not going to ask you to play Nostradamus today. But I do want to talk about Judge Benitez's decision. So this was the second time that Judge Benitez found this law to be unconstitutional, right?
Yes, there were several cases that were litigated in front of Judge Benitez before the Bruin decision came down. And we won this case in front of Judge Benitez that first time around. Same with the Miller case on semi-autos and Duncan on magazine bans. And all three of those cases went up to the Ninth Circuit. And while they were pending there, they were all bottled up behind Duncan. We won Duncan in front of the three-judge panel. We lost 7-4 in an en banc panel. We asked the Supreme Court to take the case. They sat on it until Bruin came down and then remanded it back, vacated the loss, remanded it back down to the en banc panel to reconsider their ruling in light of Bruin. And the en banc panel took all the cases that were pending in the Ninth Circuit and sent them all back down to Judge Benitez to reanalyze under Bruin, which is what he has been doing for the last 2 years. He's got the Miller semi-auto ban case, the Duncan case again, and the Rody case. And the Duncan case came out from Judge Benitez the second time around. The Duncan case came out from Judge Benitez about a month and a half ago, I want to say. Then the Miller case came down, and now the Rody case has finally come down. And there's one more pending there on billy clubs. We'll have to see what he does with that one. I mean, it's not just about firearms. It's about any bearable arm. In fact, for offense or defense, body armor is covered too.
Right.
So,
yeah.
So we'll see what he does there. And that should be really interesting because the states are trying to claim that the only arms that the Supreme Court has said are protected are arms that are used for self-defense. They would prefer that they didn't get into hunting or competitive or recreational shooting or any kind of target shooting, any recreational use of a firearm or training at a range. They don't want any of that to be covered by the text of the Second Amendment. So they're playing these games just like they did after Heller, trying to distort the Supreme Court's instructions so that some of these judges who are pre-inclined to try and uphold laws will be able to, because they'll twist that test. So hopefully the Supreme Court will straighten it out. In the meantime, all of that methodology question is bottled up behind Duncan again, and they just stayed the Miller assault weapon case, quote unquote, until Duncan gets decided, because Duncan's in front of an en banc panel again.
Okay.
So it's all bottled up in the Ninth Circuit again, and this one is going to join that line.
Yeah, but Duncan, you say, is before an en banc panel at the Ninth?
The same en banc panel that they had the first time around where we lost 7-4. Now that means we got to change two minds.
Yeah.
And did Bruen change two minds? And it sure should. I don't know that all 7 of them are such ideologues that they're not going to listen to what the Supreme Court says, but we're gearing up to argue that case in front of the Ninth Circuit en banc. We'll now have to get ready to argue this case where the Miller case was just argued. We argued the Bolin case on the California roster. There's a number of other cases pending up there, all of which are the DOJ, the state of California, are going scorched earth on. Also the SB2, the sensitive places law that would have prohibited CCW holders from carrying in places where they had been allowed to carry for 100 years. And so we struck that one down. So we've got a lot of wins. We've got a lot of wins coming on our belt.
Yeah,
but we need to hold on to them all. And ultimately, I suspect the Supreme Court's going to have to reiterate once again that we meant what we said in Bruen, and you guys are ignoring it.
Right.
Do it over.
Yeah, and or reiterate what they said in Heller, where they said that the central component of the Second Amendment may be self-defense, but the central component would indicate that there are other components of the right to keep and bear arms that
they said
are not
more than
related.
That. They said all lawful
purposes. Right. Yeah.
It's not self-defense is just one lawful purpose.
Yeah. Yeah. So again, you talk about the misreading of what the Supreme Court has said here, the intentional misreading, I think. And we're certainly seeing that around the country. But let's talk about somebody who actually does adhere to the Constitution and who did follow the Bruen test, St. Benitez in Rhodey. I want to. There were a couple of arguments here, right? That not only did this California statute violate the Second Amendment, but because California residents were prohibited from driving into Arizona or Nevada or any other state,
right,
purchasing ammunition and then bringing it back to California, that was a violation of the Dormant Commerce Clause.
Yes.
And Judge Benitez agreed, indeed, this is not just a violation of the Second Amendment rights of California gun owners, but it implicates other rights as well.
Yes, because it does. We don't just file Second Amendment. I remember before Heller, we had nothing but other claims, due process,
right. Commerce
Clause. And finally, Heller gave us the Second Amendment argument firmly established, or I thought firmly established. But all those other things, all those other legal arguments, constitutional infirmities that these laws suffer, we argue them in every case.
So one of the things that I'm just going to quote a little bit of the decision here. Judge Benitez said the Attorney General did not identify a single historical law that required a citizen to pass a background check in order to purchase ammunition, because those laws don't exist, right? They're just not on the books. No. But he also said that the analogs that Bonta offered failed to pass muster. He said, what are the 50 historical laws dating from 1789 to 1868 that the Attorney General has compiled as potential historical analogs? One would expect to find laws or ordinances that required a gunsmith to check with a local sheriff before selling a firearm. Or one might expect to find laws that restricted gunsmiths from selling to any customer who was a stranger in his community. Or maybe there'd be historical laws uncovered that require a customer's proof of citizenship before a merchant was allowed to sell him gunpowder. Those could be apt analogs to demonstrate a related historical tradition of constitutional regulation. Nothing like that appears in the state's compilation of laws. The state's compilation lists 48 laws which made it a crime to possess a gun and ammunition by Negroes, mulattoes, slaves, or persons of color, and 2 laws that prohibited sales to Indians. For example, he writes, the Attorney General listed a 1798 Kentucky law which prohibited any, quote, Negro, mulatto, or Indian from possessing any gun or ammunition. An 1846 North Carolina law offers another example wherein it was prohibited to sell or deliver firearms to, quote, any slave. Judge Benitez then said, this is the 3rd time that the Attorney General has cited these laws in support for its laws and restrictions implicating the Second Amendment. These 50 laws identified by the Attorney General constitute a long, embarrassing, disgusting, insidious, reprehensible list of examples of government tyranny towards our own people. And those are the laws that, again, the Attorney General is citing in defense of California's laws. I hope that line left a sting with Rob Bonta, Chuck.
I hope so too. I think Gavin Newsom, he needs to have that tattooed on his forehead, because this is what they don't get. I mean, they are marching down the road to tyranny by disarming people. That's what it's always been all about for Newsom and the anti-gun owner bureaucrats in Sacramento. It's murdering the gun culture. It's culture side. They want to do everything they can so that people cannot exercise their right to choose to own a gun for sport or self-defense or to defend their family. They want to make it take too long, too much red tape, cost too much money. I mean, and that's playing out with the concealed carry permits that, we're suing the LA County Sheriff right now because it's taking them a year to process applications. And Laverne and San Jose are charging $1,000 to go through the application process, which only gets you a CCW for 2 years. So people can't afford that.
Right. Oh, by the way, congratulations on Crossroads of the West gun show, hosting a gun show at the Orange County Fairgrounds. That we talked about earlier victories. That's another victory. And again, an attempt by the state to kill off lawful gun ownership and a culture of lawful gun ownership in the state.
Right. They don't want people to get together and be able to talk about how much fun they have at the range, or how the government doesn't know what it's doing, or what guns really do and don't do, that the politicians distort. I mean, they anything that allows that kind, and the gun show case was a First Amendment case, really, more than a Second Amendment case.
Mm-hmm.
They want to close public forums. Never mind, they build these fairgrounds as public property, and then they won't let anybody else build any kind of a competing fairground. That's the only venue that's available for a larger event.
Yeah.
And then they want to exclude the events that send a message they don't like. I mean, that's what the First Amendment is all about. The government does not get to have this viewpoint discriminatory approach where they don't like what you're saying, so they stop you from being able to say it in a public forum where anybody else can go say it. So yeah, it's kind of, well, I say this to you, and I know it's not amazing to you, how screwed up, how tyrannically inclined some of the progressive, quote unquote, governments are, and they just think that the ends justify the means.
Yeah,
and the ends for them is a big government nanny state where they tell you what to do, and you depend on them for your own personal safety.
Right. Right. Absolutely. Which, by the way, I don't consider to be a progressive viewpoint at all. I consider it to be a very regressive viewpoint. And in a way, it is amazing. Even to me, I've been covering this issue for 20 years now. The recalcitrance that we see on the part of the anti-gunners, the refusal to acknowledge not only the plain text of the Second Amendment, but again, the Heller decision, the Catano decision, McDonald, Bruen. Again, I'm talking to you from Virginia, where, Senator Harry Byrd in the 1950s launched massive resistance after Brown versus Board of Education came down, encouraged public schools to shut down rather than integrate. So, and that's exactly what this reminds me of. And I know there's going to be offensive to people like Gavin Newsom. Well, tough noogies, Governor. This is reminiscent of the massive resistance to civil rights that we saw in the South in the 1950s and 1960s. It is a refusal to acknowledge a basic fundamental civil right, to impede that right as much as possible. In this case, it's not. Look, in Virginia, it was telling an entire class of citizens, you don't have access to any of your rights. This is California telling everybody, you don't have access to this particular right, but it is still just as egregious and fundamental a violation of civil rights as we saw in Virginia in the 1950s and 60s.
Absolutely. I mean, I keep going back to those parallels, not to say that, this and the Second Amendment rights and civil rights of African Americans or other minorities are on the same exact par, but the response, the thumbing their nose at the Supreme Court is the same.
Yeah, it is. And again, history has not looked kindly on Senator Harry Byrd, and at some point you even saw, George Wallace renounce his segregationist ways. Maybe that was for political expediency. Maybe that was a true change of heart. But, it gives me a little bit of hope that maybe one day Gavin Newsom will admit the error of his ways and acknowledge that, okay, yes, I was wrong. I'm not holding my breath that that's going to happen. Certainly not anytime soon, but I'd love to see it.
He's not going to see the light. He's just going to feel the heat. And that's what we have to keep bringing.
Absolutely. All right. So next steps, we know this is going to the Ninth Circuit. As you say, everything's sort of bottled up behind Duncan. Do we have a date for oral arguments for Duncan in the Ninth yet?
I think it's May. I'm not positive.
So there it is. It has been scheduled.
Yes.
Okay. So, do you get the sense, Chuck, that is the Ninth Circuit, because, for a long time, I felt like the decision to kick all of these cases back down to the trial court was an attempt to delay their return to the Supreme Court. Is the Ninth Circuit acting with due diligence now, or do you think they're still playing these sorts of games to drag out the appeals process?
Well, that kind of remains to be seen. If it goes as scheduled, it's a little long, but it's not egregiously long.
Okay.
Delay. Remanding it all the way back down to make it take 3 years to get back up to them. Yeah, that was a delay strategy. But if they actually have the oral argument and issue a decision within a couple of months, that's acceptable. But what might happen, though, is, remember, we had this dissent by Judge Van Dyke about whether or not it should be sent back down again, and then whether or not it should be accepted right straight to the en banc court rather than going through a 3-judge panel first, where he called out some shenanigans by the Ninth Circuit en banc panel, saying this should not be the composition of the en banc panel that hears this case. Because these senior judges are retired, and senior judges aren't eligible to serve on an en banc panel. So you should redraw the panel. So one of the things that the Ninth Circuit then threw back at us and said, brief whether or not this panel is properly constituted. Now, if they want to delay it, they can say, oh, you know what? We're not. So we're going to draw a new panel, and you can brief it again, and we'll argue it again in 6 months. If they do that, we're probably going to ask the Supreme Court to intervene and take it away from them, because that's just a bridge too far in terms of trying to sabotage a decision, because they're hoping that Judge Thomas gets hit by a bus. They're hoping Biden gets elected, and some of these judges have to retire, and Biden gets to put new ones on the Supreme Court and stack the deck against us. And that's why elections matter, and everybody better get out there and vote for, I'm not a huge fan of Trump's personality, but his administrative policies were pretty much spot on. So as opposed to Biden's, so.
Yeah, and that may end up being a deciding factor for a lot of voters, when it all comes down to it. I mean, there's a significant chunk of Americans who I think would prefer two completely different candidates from both major parties. But, I suspect that's what we're going to get. And that is going to have to be the choice that the voters make. Yeah, because, again, the Supreme Court has already accepted Duncan, right? So it's not like the Supreme Court, as you said, they granted, vacated, and remanded.
They did a GV. It's called a GVR. They granted review.
Yeah,
but they didn't take it. They didn't take it all the way. They just simply vacated the Ninth Circuit's en banc decision.
But does that guarantee that they will hear this case, or if it gets back into the Supreme, it does not?
Not necessarily, but they probably. But the odds are good. But just the fact that they GVR'd it raises its profile with them, but does not mean they take it again.
Okay. So it's not a
So
guarantee.
they granted review.
Mhm.
They vacated the decision without having any further proceedings in the Supreme Court. Then they remanded it back down to the Ninth Circuit. And then the Ninth Circuit en banc panel remanded it back down to Judge Benitez. So we had to work
Gotcha.
our way back up again.
Yeah. Yeah. At least we haven't seen any Ninth Circuit games like we've seen in the Fourth Circuit where, the Bianchi case was held by that 3-judge panel for over a year. It seems like they were getting ready to release it. And all of a sudden the Fourth Circuit says, hey, you know what? Actually, timeout. We don't need to see that decision. We're going to go ahead and take this case en banc preemptively.
Straight en banc. Yeah.
Mhm.
That's some pretty
hinky stuff, right?
That's shenanigans.
Yeah. So how do you feel right now, Chuck? Obviously, you're excited about this case, but generally speaking, I mean, do you feel optimistic? Do you feel confident? Let's say, and again, as you say, a lot of this depends on what happens in November, right?
Yes. Look, I mean, I would say the odds are in our favor. From Hunger Games, the odds are in our favor, but it's not a battle that we can't lose. We could lose depending on whether or not the Supreme Court gets spooked or stuffed with hostile judges. I mean, that's the kind of the saddest part of this. You go to law school and you think, well, if I reason things out and make the better argument and connect all the dots, I have to win. Well, no. The courts can really distort the facts and distort the law to come up with a result that they're looking for.
Yeah.
Even if it's dead wrong.
Oh yeah.
So,
we've seen that so many times since Bruin. AR-15s aren't protected by the Second Amendment. You can't challenge this carry ban because there's no evidence that the state's ever going to enforce it, even though the state says it's going to enforce it. I mean, there have been some crazy decisions. But there have been a lot of good decisions too. Don't get me wrong.
Right.
But
it depends whether they faithfully apply Bruin or not. If they twist it, we can lose. If they apply it like the Supreme Court intended it to be applied, we win. Unless there's it's not every law that's going to be struck down. There are some historical laws. It wasn't just a free-for-all back in 1791. There were some restrictions on carrying certain weapons, like you couldn't go around terrorizing the countryside.
Right.
But it was always pretty much individualized against behavior, not the individual gun and not a class of people. So, the gun control laws back then were much more practical because they went after the bad guy,
Right.
Not the
Absolutely.
bad gun or the bad place or so it's some of these laws, you can't murder anybody. You can't shoot somebody. Those laws are going to stay up. They're going to, they're going to remain in place. But laws that don't accomplish anything, that the state cannot prove really do any good, and they almost never can, those are all subject to being struck down. And the weird thing is, because the state of California got away with this for 20 years now, just piling on over those 20 years, and they weren't struck down. Now they think that those were all givens. They were constitutional. Well, we've been telling the politicians they were unconstitutional the entire time.
That's right.
It just took us a while to get a court to confirm what we were saying.
Hey, you talked. You said earlier that Gavin Newsom should have that quote from Benitez tattooed on his forehead. I think since that's not going to happen, I think maybe as a backup, California Rifle and Pistol Association should sell T-shirts with Rob Bonta and Gavin Newsom's face on it, and then that quote by Judge Benitez underneath: these 50 laws identified by the Attorney General constitute a long, embarrassing, disgusting, insidious, reprehensible list of examples of government tyranny towards our own people.
We at least need to get a meme out there about that.
Right? I'm thinking you might be able to sell enough T-shirts to fund another lawsuit, though. I'd buy one of those things.
Yeah, not a bad idea.
Hey, Chuck, listen, man, thank you so much for carving out a few minutes of your day. I know that this is an incredibly busy time for you. I'm looking forward to chatting again. Give my best to Sean Brady as well, the lead attorney working in this case for Michel and Associates. You've got a fantastic
Sean and the whole team.
You've got a fantastic team. I love talking with you, but I got to tell you, I've had the opportunity now to talk with Tiffany Chevron, with Costas Moros, with I'm blanking on her name. Barbier, Barbier. So I think, is Sean the only attorney that I have yet to speak with?
Maybe I'll have to get him on for you.
I think so.
Probably to talk about Illinois. There's some hot things going on there that he's taking the lead on.
All right. Well, the next time we speak with one of the Michel and Associate attorneys, perhaps it'll be Sean Brady talking about Illinois. But in the meantime, make sure that you are following what's going on in California. CRPA.org is the website. Second Amendment Law Center, again, for cases beyond the state of California, 2ALC.org. Is that correct?
Correct. And we really do need people to join our team. Come on. It's a winning team, fellas, boys and girls. Jump on board. Okay. If you're afraid of getting on a list, sign up your dog. Okay. We got plenty of Fido members of CRPA. It's not a problem.
There you go. And who knows? Maybe you'll give it a T-shirt out of the deal too. Chuck Michel.
Remember, all our lists are complete. Nobody's ever gotten our list. So
good to know. Good to know.
All right.
Chuck Michel, thanks so much, man. We'll talk to you soon.
Love you, brother.
Thank you once again to Chuck for joining us on the program. Looking forward to having him back, as well as Sean Brady. We got to finish off our interviews with the Michel Associates, or I guess the associates from Michel and Associates. And hopefully we'll be able to do that in the very near future. Right now, let's turn our attention to today's armed citizen story, our good deed of the day, our recidivist report, which, again, doesn't necessarily feature somebody who has been previously known to law enforcement, but it is one of those, what the heck are they thinking decisions? All right, so here's the headline from the Chicago Tribune, actually the Post-Tribune newspaper. Cherville man gets 5 years probation in hatchet attack. And it was an attack. I saw the headline. I thought, okay, well, maybe like he brandished the hatchet. Well, no. Oh, no. 30-year-old Jason Kalbach was originally charged with multiple felonies, including attempted murder, aggravated battery, criminal confinement, 4 counts of battery by means of a deadly weapon, and battery resulting in serious bodily injury. Now, that laundry list of felonies was tossed out, and Kalbach was allowed to plead guilty to 1 count of criminal confinement, which is a level 3 felony in the state of Illinois. According to police, Kalbach's father called 911 back on February 24th of 2021. So again, this case has been dragging on now for almost 3 years. Anyway, Kalbach's dad called 911 after the victim in this hatchet attack escaped from a bedroom in the Kalbach home, and Kalbach's dad saw the extent of his injuries. During the 911 call, Kalbach's dad reported that his adult son had bludgeoned his friend inside the residence. There was blood, quote, all over. The victim, a 26-year-old Cherville man, told police that he had been living with Kalbach for about 5 months and had been told by Kalbach he wasn't allowed to leave the home. The Cook County, or the Cherville Deputy Police Chief, Jeffrey Cook, said that the victim further reported that Kalbach had blamed him for all the problems in his life and became physically abusive to him over the last 48 hours. When officers and detectives responded to the home and they met the victim, they described 2 black eyes, said he was bleeding profusely from his left arm. The victim showed officers several other places on his body that were bleeding, said he believed that both of his hands had been broken. The deputy police chief said investigators determined that over the last 48 hours, Kalbach had handcuffed the victim, locked him in a bedroom where he tortured him using several different deadly weapons. Victim alleged that Kalbach had struck him several times with a hatchet, had used a taser, had used a police baton, as well as brass knuckles, to beat and torture him. And again, Kalbach was arrested, charged with numerous felonies. And here we are, almost 3 years later, after that attack was reported to police. Kalbach pleads guilty to 1 count of criminal confinement. He actually pled guilty back in December, but the sentence was handed down on Wednesday again. 5 years probation. Oh, and prosecutors said, well, you got to enroll in anger management classes. Oh, yeah, and we might make you complete a substance abuse program. Governor J.B. Pritzker and Illinois lawmakers, Democratic Illinois lawmakers anyway, want to put gun owners in prison if they violate any of these states' gun control laws, right? There are criminal penalties attached if you do not register your so-called assault weapon with the Illinois State Police. But you beat, bludgeon, and torture someone over a span of 2 days, and you get a slap on the wrist. Not even with brass knuckles, just a polite little tap, and be on your way. I mean, this is absolutely insane. Cannot say that justice was done here. But Illinois is so topsy-turvy right now, criminalizing the exercise of a fundamental constitutional right and letting violent offenders off with no consequences whatsoever. Today's armed citizen story, this is a crazy one as well, from Louisiana, Ponchatoula, Louisiana, where residents shot out tires to help capture a burglary suspect. Another armed citizen held a burglar at bay until police arrived on the scene and was able to take him into custody. Happened over the weekend, last Saturday. There was apparently a 3-person burglary ring that had been accused of burglarizing homes and vehicles and then trying to sell what they had taken out of the back of a U-Haul truck. 2 suspects, 27-year-old Zachary LaFleur, 37-year-old Amber Skelton from Ponchatoula, have been arrested. Authorities say that a third suspect, 29-year-old Branson Monsiter of Ponchatoula, is still at large, at least as of this report, and is wanted on several counts of burglary and possession of stolen things. According to Sheriff Daniel Edwards, no relation, by the way, deputies called out on Saturday to the Creekside subdivision in Ponchatoula, where homeowners had chased and cornered LaFleur. After a homeowner came upon him burglarizing his residence, he then yelled out for help from, hey, neighbors, this guy's stealing my stuff. The sheriff's office had a second homeowner whose home had also just apparently been burglarized a couple minutes earlier, came over to his neighbor's aid. LaFleur managed to escape the pair and get into a truck, but that's when one of the homeowners discharged a firearm into the tires of LaFleur's vehicle, according to the sheriff, rendering it disabled. So LaFleur couldn't get away behind the wheel. Instead, he tried to escape on foot. A couple minutes later, another neighbor heard his home security alarm going off. After being told by neighbors that there was a burglary suspect in the loose, the homeowner walked around his property and found LaFleur inside a truck that he owned. Yeah. That's when LaFleur was held at gunpoint by the homeowner until deputies arrived. Deputies say they later determined that the alarm the man heard was triggered when LaFleur attempted to break into a nearby house to hide out. So LaFleur is then in custody. The investigation still continues. Deputies were told of a U-Haul truck that had been seen in the Creekside subdivision, which was now parked outside of a discount tobacco shop in Ponchatoula. And there were 2 people who were allegedly selling stuff out of the back of the truck. So police went to the scene. The suspect, identified as Monastery, fled just before deputies arrived, but Skelton apparently was apprehended at the scene. LaFleur has been booked on 2 counts of residential burglary, 2 counts of vehicle burglary, 1 count of attempted burglary, 1 count of simple criminal damage to property, as well as 1 count of illegal possession of stolen things. Skelton, meanwhile, booked with 3 counts of residential burglary, 1 count of vehicle burglary, and 1 count of illegal possession of stolen things. Monastery wanted for 3 counts of residential burglary, 1 count of vehicle burglary, 1 count of illegal possession of stolen things, as well as 1 count of failure to appear in court. So apparently this is not his first run-in with the law. And again, the 2 of the 3 suspects apprehended will now face charges. We'll see again what type of plea deal is offered to them in the future, but at least taken into custody, thanks to the fact that there were armed homeowners there who were able to prevent their escape and held them again until officers arrived on the scene. Finally, today's good deed of the day: in the right place at the right time, willing and able to do the right thing. A couple of police officers in the Miami, Florida area who have helped a woman get back on her feet after a series of unfortunate incidents ended up with her living in her van. It happened the day after Christmas. I guess it started the day after Christmas. There's a woman named Maria Isabel Garcia. She said, I had a problem with my car and my battery. And so she was just kind of stuck, right? A police officer, Leonard Cantave, happened upon Garcia. He said, it's the holidays. She's alone. There's no gas for her car. It's pretty sad, and I'm blessed enough to help her out. So he thought, I'll get you, some gas for your car, and you can be on your way. But then they started talking. He said she was pretty much homeless. So I took her to the gas station. I filled up her tank for her. I went to the mechanic shop, and I spoke to the owner, and they gave her a brand new battery for her car. Garcia said, he asked me what had happened. What happened to you? You live here. Why? And I explained to him I don't have a job at this moment. It's back during the pandemic when things started to go south. She lost her job as a security guard, and then her license expired. She didn't have a job, so she didn't have the money to renew her security guard license. And then she just things just fell apart. She was stuck and has been since then, living out of her van. Garcia said, I don't have anybody. I don't have family. I don't have friends. I don't have a husband. I don't have anybody. She said, I've cried so many times inside this car alone, but nobody saw me. So Leonard Cantave wanted to help. He reached out to his friend, Nicole Sears, who's a dispatcher in the Miami-Dade Police Department. And the two of them, within a month, because again, this was the day after Christmas, raised enough money to renew Garcia's car insurance and her registration, to renew her security guard license so she could find gainful employment again, and gave her some gas money. As CBS in Miami reports, those little steps were enough to get Garcia back out there and on the job. She's working again as a security guard. She's applying for housing, and the officer and the dispatcher say that this is the beginning, not the end of the story. Leonard Cantave says, I just started it, and I want to finish it. Make sure she gets a house, hopefully gets a better car, and then once that's done, I think my job is done. Then on to the next project. Maria Garcia told Cantave, I love you. She said, I love him so much because he's a good person. He's a good guy. He's an angel. He's my angel. And there really is, it sounds like, going to be another project in the future. CBS in Miami reports that Sears and Cantave have actually started a nonprofit to help others in situations that are similar to Maria Garcia's predicament. It's called Blue Hearts of South Florida. Looking forward to hearing more about it. But, again, this was just a random encounter, right? And Leonard Cantave, listen, he could have done a nice thing for Garcia. He could have filled up her gas tank. He could have, reached out to that auto supply company and said, hey, we got this lady. Can you give me a discount on a new battery? That alone, I think, would have been worthy of a good deed of the day, right? But they went so much further to help this woman get back on her feet. And again, just a few small things making a life-changing difference for Isabel Garcia. So in the right place, at the right time, willing and able to do the right thing for someone in need. Leonard Cantave, Nicole Sears, we thank you for your very, very good deed. And that is all the time we've got for you on this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program as always. I'm looking forward to being back with you again very soon. In fact, we might have a special Friday edition of Bearing Arms Cam & Company, so stay tuned for that. But also, be sure to check out BearingArms.com throughout the day. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation. We've got legislation, we've got litigation, we've got armed citizen stories, and more. Again, you can find it all at BearingArms.com. If you like what you see, I'd also encourage you to become a VIP or VIP Gold member. Just go to BearingArms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your membership. We're going to say thanks by giving you exclusive content you won't find anywhere else, because your support really does make a difference, and it truly does matter. Thank you again. And enjoy the rest of your Thursday. We'll see you back here before too long. Until then, be well, be safe, and be free.